Hi, welcome to Legal Penguin, the show where I read and summarize a legal case so you don't have to. I am your host, not a legal specialist or a legal advisor, and anything that is said on Legal Penguin is not and should not be taken as legal advice. This is all just information that's available to the public. It's on the internet. Taxes. No one wants to pay them. No one knows how to truly calculate them. They're always way too high. And I'm sure at some point we've all thought of, what would happen if I just decided not to pay them? What are they going to do to me? Find me? Arrest me? So today we're going to be looking at the SIP Project Managers versus the Commissioner for South African Revenue Services. This is SARS as we know them. And this is a 2020 case that was heard in the High Court. We're going to see one of the things that can happen to you when you decide or when it happens that you owe SARS money. SIP Project Managers are a construction company that has been in business for about 36 years. They are a registered taxpayer and they use the e-filing system or the electronic way of basically filing their taxes. SIP is therefore our applicant in this matter and SARS is therefore going to be or is the respondent. We have to take it back all the way to June 2019 where our applicant SIP, they filed their tax returns and they concluded that SARS actually owed them 1.6 million. Okay, so this is the money that they were going to expect back from SARS. Upon receiving the taxpayer's assessment, SARS wasn't really sure about how they felt about this, and they decided that they need to verify. They need to verify. And so they asked the taxpayer, hey, can you send more documents so we can make sure? But the taxpayer did not furnish these documents. So the taxpayer didn't send these documents over. And as a result, SARS issued an additional assessment. And you won't believe what this additional assessment said. So in this new assessment, SARS found that the taxpayer actually owed them an amount just over 1.2 million, which is it's a little... Anyway, so SARS found this, then they issued this additional assessment, they sent it out to the taxpayer's e-filing profile, they loaded it on there, but in no fault of SARS, of course, this additional assessment didn't come to the notice of the taxpayer, so the taxpayer didn't even know that they got an additional assessment, and this amount that the taxpayer had to pay was due on the 30th of November 2019. Remember this date because dates are very important in this case. Very important. On the 3rd of February 2020, now this is the following year, the applicant's bank gets a notification from SARS that the bank, has to pay, a small amount, just over 1.2 million from the applicant's bank to SARS. So they have to do it as a third party, essentially. So on the 6th of February 2020, the applicant's bank calls the applicant's accountant, Abe, by the way. Yes, his name is Abe, Abraham's son, but we're good. We're friends here, right? So his name is Abe. They call Abe and they say, hey, so crazy stuff is happening, right? So SARS just told us that we need to pay them money from the applicant's bank because the applicant owes them money, right? Okay, thank you, bye. And on this day was the first time that the applicant and their accountant, Abe, were becoming aware that they even owed SARS any money. On the 6th of February 2020 was the first time they were becoming aware of any of this. It's important to note that at this point, no letter of demand had been sent to the taxpayer's profile or their e-filing profile. No letter of demand was sent to them. And this is a very important step that must be fulfilled before you can go asking for money from a third party. So before you can go to a taxpayer's bank or a taxpayer's employer, you first have to send a letter of demand to the taxpayer. They have to know what's going on. So Abe, the accountant, he immediately gets into action, right? He applies for an objection to the additional assessment, and then he also applies for a suspension of the payment until the objection has been processed. But unfortunately for Abe, the accountant, he was too late. He was too late at this point, and the payment had already been made, because there's actually a rule called pay now, argue later. So you pay now and you argue later, literally. I would love to hear what you think about this rule. Do you think it's fair? Do you think that it's justifiable? Do you think it's a little anti-progress? I want to hear what you think about this rule. So you can just tell me that in the comments down below. Abe, the accountant, is still hard at work. He wants to figure out what's going on. So he gets into contact with the SARS official who had issued the letter to the bank. And this official was a senior official, and her name was Mrs. Pty. And he gets into contact with her and he asks her, hey, what's going on? What's going on? What happened? What was that? What was that? And Mrs. Pty tells him, we did send a lot of letters of demand. We did. And then she forwards him these letters on that day. So on the 7th of February, this is the first time that Abe is seeing these letters. He's looking at them and he's saying, I have never seen these letters before. I think I would remember. I'm an accountant. Abe, the accountant, upon looking at these letters and concluding that, okay, yes, I've never seen these letters before, he gets into contact with an employee, so another employee of SARS, and this is an employee that works at the call center. So he calls the call center and he is assisted by Mrs. Campbell. He explains the whole situation to her. Mrs. Campbell says, okay, let's get to work. Let me do my job. Let me see how I can help you. And they pull up the taxpayer's e-filing profile. She looks at it and she says, well, this is funny. I can't seem to find any letter of demands on this e-filing profile. So she also concludes or confirms that no letter of demand was sent to the taxpayer's e-filing profile. So all of what I've just explained led to an application being brought before the court. Hence, we even have a case that we're talking about right now. And the section that was confirmed or focused on in court was section 179 of the Tax Administration Act, especially or specifically subsection 5. Subsection 5. A quick crash course. Crash courses are quick. Okay, a little crash course on what this section basically says. The principle allows for a senior SARS official to basically issue out a notice to a third party who holds or will hold money that belongs to the taxpayer. So they are allowed to basically request that this third party takes the money, that they're holding for the taxpayer and pays it over to SARS to fulfill or to satisfy outstanding debt. This is very, very important. Outstanding debt that the taxpayer has. So what we're picking up from this is the taxpayer has to owe SARS something for SARS to be allowed to enforce this rule to get money from a third party, example, bank, employer. Subsection 5 then goes into detail about the circumstances or the rules that surround sending this notice, or more rules. And it basically says that 1, a final letter of demand must have been sent to the taxpayer before you can issue out a notice to a third party. And number 2, this letter of demand must be sent at least 10 days before you send out a notice asking anyone to be paying this taxpayer's debt. It has to be sent at least 10 days before. It also goes on to mention a whole lot of other requirements. If you want to go look into those, I would recommend that you do, because it could be very helpful. So our legal conflict here is that the applicant is arguing that SARS did not send a letter of demand to them before they sent a notice out to a third party. The respondent then argues, no, we sent letters of demand. In fact, we're going to rely on the one that we sent on the 7th of November 2019. And if you remember all the dates, you might already see what the problem here is. The applicant then argues, okay, if the court finds that a letter was sent out, especially on the 7th of November 2019, the debt was only due on the 30th of November 2019. What are you collecting? There is no debt due at that point. There's nothing for you to be collecting. And so the applicant was asking for the court to rule the notice sent to the banks as null and void. Essentially, all SARS had to do was prove that these letters were delivered. But let me tell you how that went, okay? So Mrs. Tati, the senior official, she contradicted herself multiple times on the ways that the letters were delivered, right? She had many different versions on how they were delivered. And at some point, she clearly showed that she did not even know if these letters were actually delivered. And then number two, the respondent, SARS, failed to address the fact that their own employee, Mrs. Campbell, had confirmed that these letters weren't uploaded. They just forgot to address that. They just, oops, these things happen, right? Number three, they provided an annexure. Yes, that's good. But this annexure only proved that the letters existed, not that they were delivered. So that's their argument. On the other side, the applicant provided an annexure that showed that, hey, look at this, look here, no letter is on my e-filing profile. No letter of demand has been uploaded or was ever uploaded to my e-filing profile. And to no shock, really, the court ruled that, okay, yes, the letters were not delivered, were not sent, and therefore the notice was null and void. So the notice that was sent to the bank was null and void. Upon this ruling of the court, what do you think SARS's response was? Do you think they said, A, we are truly sorry, we realize our mistake, we will pay back the taxpayers' money because our notice was null and void? Do you think it's B, we'll see you in court, we're going to appeal? Or do you think it's C, let us keep the money because the taxpayer owes us, from the additional assessment already, so don't make us give it back. We shouldn't have to give it back. It would be, a waste of time. If your answer was C, you are correct. SARS's response was, yes, okay, maybe we got this money through the wrong ways. Maybe there was a mistake there, but the taxpayer owes us money from that additional assessment. So if we give it back, but then we're going to just take it back again, that's, just let us keep it. And the court said, no, SARS, if we let you keep money that you obtained through the wrong channels or the wrong ways, we're basically saying that section 179, especially subsection 5, has no purpose. We're basically saying, we can just skip all over the rules and regulations. They don't matter. And so the court said, no. Give the money back. Give the money back. SARS had to pay the money back with interest, and they also had to pay the applicant's costs for the application. And that actually brings us to the end of this case. There are a lot of criticisms about the judgment in this case, about how it was handled. I personally think, this is my personal opinion, I think that it was the right call for the courts to do what they did, because it basically reaffirms that no one is above the law and that we should all follow rules and regulations that are in place, because they're in place for a reason. I would love to hear your opinion on this, your thoughts on this whole matter, but that is indeed where I will have to stop it for today. Thank you for joining me today. Thank you for joining us today. How could I be so rude? Don't forget to like and subscribe, because that is important. I will tell you that. And if you have any case suggestions, cases that you want me to read, summarize, or cases that you just want us to talk about, please be sure to leave those down in the comments below. I will be reading those, I promise you. But until I see you next time, good luck and goodbye.